As we begin our inquiry in the 11th module, we are armed with the knowledge and information about the tentative, amateurish steps taken by India in environmental justice dispensation through crafting of laws and creating institutions. They were quite impressive to start with, but could not deliver and sustain themselves, petering out either because of the fact that they were ill equipped or did not get the kind of support they deserved. Be that as it may, we have two illustrative examples in the form of the National Environment Appellate Authority Act 1997 and the Environment Tribunal Act of 1995 as illuminating this idea, which we discussed in the last module. In this module, we will witness a phenomena, a phenomenon of the birth of a professionalized, specialized environmental justice delivery outfit and its working, the National Green Tribunal (NGT), and in the later part, we turn towards the very arrangements that exist in the existing body of environmental legislations and the enforcement mechanisms within them to explore the latent and patent avenues available for environmental justice delivery. We first begin with the National Green Tribunal as the first segment of our discussion on environmental justice dispensation, the second part, the National Green Tribunal 2010. Look at the background, the mandate, organization, and jurisdiction of this entity, which I refer to as a phenomenon. It was not something that just came overnight. It was a very well thought out and very well planned, desired work of great care. It was out of a felt need for a specialized environmental court. And this desire was not just felt by any ordinary entity, but even by the Supreme Court of India. Recall, way back in 1986, in the Oleum gas leak case, MC Mehta versus Union of India, the Supreme Court insisted that we do need such a court to help reduce the burden of litigation in the higher courts. And much later, in 1999, the Supreme Court had even given a direction to the central government in the AP Pollution Control Board versus Professor M.V. Naidu to create a specialized environment justice delivery system which would bring both the expertise in relation to environmental issues and the judicial acumen into play. In its 186th report to the Law Commission, all this has been very elaborately stated, and it examined several kinds of models that are already in existence and what India can gain by creating such an institution. And this report was a kind of a clincher. The government had already toyed with so many experiments, which we saw in the previous module, and finally decided on such a kind of an arrangement, and that resulted in the National Green Tribunal Act 2010, NGT for short. India is the third country after Australia and New Zealand to have come up with such an effort, and this happened in 2010. By 2016, just in about 6 years' time, if you take a panoramic view of the system that was developed all over the world over 1,200 environmental codes are reported to have already been established in different parts of the world. What exactly is the mandate of this new green outfit? The Act stipulates three clear objectives. One, effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources. Please note, it is not just dealing with cases on environment, but effective and time bound disposal of cases for protection and conservation of forests and natural resources is the prime objective. The second one, enforcement of any legal right relating to environment. And finally, giving relief and compensation for damages to persons and property, etc. So, in a way, it was a combination of the objectives of the Environment Protection Act on the one side and overcoming the defects and deficiencies that existed in our legal order in not being able to compensate, give relief to the sufferings of the people on account of environmental disasters, primarily man made ones at that. A very broad mandate. And you cannot ask for anything bigger and better than this in terms of the set objectives which the new institutional arrangement would have to deliver. A quick look at the salient features of the National Green Tribunal Act before we look into its working. The preamble says, to give a little bit of a constitutional insulation of support, it says the objective is to carry out the constitutional obligations under Article 21. In fact, this is one wonderful thread of thought running all throughout in our thinking about environment and environmentalism, an idea kindled by the Supreme Court of India that it has a very close relationship with the human rights, the fundamental rights of the people, right to live. And that has been given expression through the preamble to carry out the constitutional obligations under Article 21, which is protection of right to clean and healthy environment as an integral aspect of right to life. And so the emphasis is on the quality of life and not just bare existence. Quality of life, life forms, human, animal, plant, and the entire environment as a whole. You cannot have stated a lofty objective in such clear, eloquent terms than what has been given here in this NGT Act. This creates a body for achieving these goals. And what is it called? The National Green Tribunal. It's a very unique body. Look at the composition. It would have a judge of the Supreme Court or a retired judge of the Supreme Court of that stature and 10 to 20 judicial and an equal number of expert members. This is very special. Actually, this is a further amplification and elaboration of the idea conceived in, remember, the Environment Tribunal Act, which we discussed earlier, of 1995 vintage. 10 to 20 judicial and 10 to 20 expert members. And who are these expert members? Expert members are those who have expertise in different areas of environmental knowledge, skill, understanding, specialization. Academic qualifications are given. So it is not just anyone who is in the know of environment. Somebody who has administrative experience also is put in this particular category. And so you are combining administrative experience and knowledge and expertise on the subject to constitute an important component of the composition of this particular body, and the counterpart, rather the other part of this body, is equal number of judicial members. So you are bringing in both the judicial acumen and administrative and research experience to combine to deliver justice. NGT would have its headquarters in Delhi and with four regional benches at Pune, Bhopal, Chennai, and Kolkata would constitute the National Green Tribunal. Each of the case that is heard by either the NGT at the headquarters or by those benches that are constituted in different parts of India, they are heard by an equal number of judicial and expert members. So, equal proportion. In recent times, in order to have a greater reach and scope for access for a large number of people, NGT constituted circuit benches in different places like Shimla, Shillong, Jodhpur, and Kochi, and many more may come, mainly to reduce the constraint of accessibility, especially for the poor and the tribal populations living in remote areas. There is a scope for co-option of experts to advise in this body of law. That explains the uniqueness of this creation and its composition. What kind of jurisdiction that NGT would have? It has two kinds of jurisdiction: an original jurisdiction to settle disputes, civil cases where substantial questions relating to environment are involved. So it's a very broad sweep of an idea of conferring upon this body an original jurisdiction on all issues which, to their major part, have issues concerning environment. Then invariably NGT is the answer to knock at its door, seek and secure justice. This includes enforcement of rights in relation to it. All that is required is, if your right is affected, apply within 6 months of that cause of action. Normally, there can be exceptions, and NGT can really take up cases even beyond 6 months if it is convinced that there is enough justification for the delay. The second kind of jurisdiction that NGT exercises is the appellate jurisdiction, to sit in appeal jurisdiction over decisions that are made under Water Act 1974, Forest Conservation Act 1980, Air Act 1981, Environment Protection Act 1986, and notifications under it, and Biodiversity Act. The appeal has to be made normally within 30 days of orders from all these legislations. NGT also deals with cases chosen to be transferred by way of reference from higher judiciary. If the high courts and Supreme Court feel that this is one subject that's before them, which should be rightly be dealt with by the National Green Tribunal, they may just pass an order to the effect that this particular case, the suitable form for litigation and resolution of conflict is the National Green Tribunal, then those cases also can come. As a matter of fact, except the Supreme Court, no other court has actually transferred cases of this kind, because, as you know, it is actually the Supreme Court which was actually the prime motivator for the creation of this body, and there are instances of Supreme Court having transferred cases before it in favor of the National Green Tribunal. We have not heard of cases coming from the High Court to the National Green Tribunal as yet. It's a time bound exercise. Since the idea is to expeditiously dispose of cases and appeals, these applications and appeals, as a general rule, the NGT is mandated to dispose of within 6 months of filing of the same. And orders also include reliefs, compensation, and even restitution. So, enormous task, but to be accomplished in about 6 months' time as a general rule. No other court or authority can entertain any claim or action that can be dealt with by the tribunal. So, this is a unique creation. When the case comes up before it, no other court can take up any such case which is before the NGT, and it is not bound by the procedure laid down under the Civil Procedure Code. But of course, it's guided by the principles of natural justice. It can lay down its own procedures. So, the kind of liberty that is given to NGT is that it is not shackled by that normal, usual court processes of filing petitions, of hearing them, of argumentation and disposal in the manner in which the courts of law would operate, but to lay down its own procedures for convenience and for expeditious hearing and disposal of cases. All proceedings of NGT are deemed judicial proceedings, and so by that token, every order issued by NGT is executable as a decree of civil court. So it is clothed with the status, role, responsibility, and functions of a normal court of law without being confined to the rigmarole procedures which have afflicted and affected them, leading to delays. A very important thing to note. And that does not in any way hinder the execution of its orders because they have the same status as that of a judicial order. What kind of powers they have? Liability may be imposed on an individual, a corporate entity, which may include a government agency, which may be in public sector or private sector, and those who are in charge are responsible for corporate environmental wrong. Every offense under this act is deemed a non-cognizable offense. All appeals from the order or what you call as decisions of NGT lies only with the Supreme Court, and no other forum can sit and appeal over the decisions or orders of NGT.